All right. Good afternoon, everybody. I'm Garrett Epps, professor of law at the University of Baltimore. I'll be moderating the panel, and before we get started, I need to make a couple of quick announcements. First, everyone in the audience, I know you've been reminded of this before, but please turn off your cell phones or at least put them on silent. Panelists are supposed to turn our cell phones off because apparently they disrupt the recording equipment somehow. Second, remember there will be time after this panel for networking. Please feel free to engage in with panelists who may be here or other people at the convention. And at 5 p.m. In the presidential ballroom, we'll hear remarks from Representative Donna Edwards, and then there'll be a reception in the congressional and Senate rooms at 6 p.m., so we hope to see everyone there. The title of this panel is Immigration, the Federal-State Showdown. And showdown, I think, is an accurate word to describe the legislative and administrative activity that's going on in states and cities around the nation aimed at alleviating what lawmakers see as the problems caused by undocumented immigration. A lot of these measures have put them on a collision course with the federal government, which under the plenary power doctrine has been seen as having almost exclusive authority over immigration issues. So the stage is set for some fairly important battles, not only about the immigration issue, which of course is quite important, but about the charged area of federal preemption, which has importance across a wide swath of fields. On May 26th, the Supreme Court decided Chamber of Commerce versus Whiting, which held that Arizona could enforce its statute that subjects employers to possible revocation of their business licenses if they knowingly employ undocumented workers. The court also vacated a decision by the Third Circuit, striking down an even more punitive ordinance passed by the city of Hazleton, Pennsylvania, and has ordered the Third Circuit to re-examine its earlier decision. Of course, the Ninth Circuit reaffirmed the preliminary injunction against Arizona's bill, Senate Bill 1070, and a number of states, Utah, Oklahoma, and Georgia, have all, among others, have enacted measures aimed at undocumented workers that range from what are seen as relatively moderate to extremely punitive. On the other side of the issue, a number of states, Massachusetts, New York, and Illinois, have indicated they won't participate in the so-called Secure Communities program designed to facilitate the deportation of aliens with criminal records. And that program is supposed to be mandatory, so this raises some interesting federalism questions. Now, that recap does no more than scratch the surface of the litigation and legislative battles that are going on across the country, and I'm happy to say that we have a panel here that will do much more than scratch the surface, and who are involved in a number of ways in these battles. And I'm going to introduce them briefly in the order they'll speak and then try to get out of their way. But in introducing them, I am going to show disrespect for every one of them because their resumes, which are in the conference brochure, are so significant and impressive that I have only got time to hit the very highlights of the highlights, and I apologize for that. Angela Kelley is Vice President for Immigration Policy and Advocacy at the Center for American Progress. She's previously served as Director of the Immigration Policy Center and Deputy Director at the National Immigration Forum. She has extensive experience in the legislative process and lobbying. Thomas Saenz is President and General Counsel of the Mexican American Legal Defense and Educational Fund, MALDEF. For 4 years, before assuming this position in 2009, he spent 4 years as counsel to Los Angeles Mayor Antonio Villaraigosa, and before that was at MALDEF for 12 years as, among other things, Director of Litigation, in which he served as lead counsel in the successful challenge to the anti-immigrant initiative Proposition 187. Deirdre Fitzpatrick is Associate General Counsel of the Service Employees International Union. She's practiced labor and employment law for 13 years, both as private attorney and counsel to the National Labor Relations Board's appellate branch. Neil Kinkopf is professor of law at Georgia State University, where he teaches constitutional law and directs the Center on State Legislation and Policy. He's a former counsel to the Senate Democratic Caucus during the impeachment trial of President Clinton, and has served at senior posts at the Office of Legal Policy and the Office of Legal Counsel of the Department of Justice. And finally, S.Greve is John G. Searle Scholar at the American Enterprise Institute. Intimidatingly enough, he is a graduate of the University of Hamburg and holds an MA and PhD in government from Cornell. He has written a great deal on constitutional issues. Most relevantly to this panel, he is co-editor with Richard Epstein of Federal Preemption, States' Powers, National Interests, and with Michael Zeller of Citizenship in America and Europe. So you can see he'll have a lot to say on all these subjects. We decided fairly early on we want to do this panel more as a conversation than a series of presentations. So for the first hour or so, the panelists will interact, asking questions, and then we'll open it up for questions. I'm going to start by calling on each speaker in order, but for a brief statement about a specific subject, but then we'll go on, and I expect each of you will be jumping in and mixing it up on these subjects. I'd like to start with Angie. I wonder whether with your legislative expertise, could you just lay out the landscape for us in terms of policy and legislation that are going on in this issue and what the context is being set for the future battles?
Sure, happy to. Thanks, Garrett, and thanks to ACS for inviting me on this beautiful Friday afternoon, and great thanks to you all for being here in this windowless room, even though it's finally not humid in Washington. So we'll try to be brief and make sure you get some time outside before you get a drink. So I want to talk a little bit about what the dynamics are at the state level right now, and how that feeds into a very interesting development just this week, where Congressman Lamar Smith introduced an E-Verify bill in the Judiciary Committee, which we expect will move pretty seamlessly through the House, and I'll talk a little bit about that. And then just a touch on secure communities, because it's getting a lot of attention, and there's an announcement that DHS is going to be making in about an hour or so about some changes to secure communities. So as Garrett said, in the absence of the federal government being able to resolve what is a very broken immigration system, states have taken matters into their own hands, and they've reacted in a lot of different ways. What gets a lot of attention is the kind of the bad news story of an Arizona or an Alabama or Georgia, which it should. But there's also kind of an interesting good news story that's told less often, which is that even though more than half the states considered immigration bills, really only a handful have passed. And even though there is enormous dissatisfaction and anger with our broken immigration system, there have been some positive bills that have passed, particularly those that would assist undocumented youth. The DREAM Act bills, the state versions, have passed in Connecticut. They've passed in Maryland and a couple other places. And so I think it really speaks to just kind of how conflicted people are at the local level. But the fact that is where the expression of trying to solve the problem is coming. And we can only hope that that's something that federal lawmakers will eventually hear. Why so many states rejected these immigration laws, I think in part gets down to like what the state budgets would tell them, right? Which is that they're in the red. A state like Kentucky ran the numbers on what its immigration bill would cost, and the $40 million price tag just proved to be too much, so they didn't pass it. In Arizona, my organization did an analysis of what was the economic impact of SB 1070, and we looked at a very narrow, specific issue of conference cancellations, right? A lot of people go to Phoenix, especially in the winter when it's warm there, maybe not so much in the summer, and we looked at how many conferences were canceled and how many conferences weren't booked. And they lost $212 million. This is a report that we issued in November, just 6 months after SB 1070 had passed. In defending against SB 1070, Arizona's already spent $1.5 million. And the second batch of bills that the Arizona State House was considering that would have had doctors checking the immigration status of people in emergency rooms. They got rejected. And why did they get rejected? Well, it wasn't because Russell Pierce finally decided that maybe he should be nicer to immigrants. It was because, I don't think that day will ever come, it was because 60 CEOs signed a letter to Russell Pierce, the head of the state Senate, saying, please stop, because this is bad for business. So it's interesting because while it's a very emotional issue, and that's often what the press covers, I do think there's sort of a sensible undercurrent that at least some states, although not all, are going to. And in the states where that hasn't worked out so well from our perspective, the Georgias and the Alabamas, where laws have passed, they generally follow the Arizona model, right, where police, if you have reasonable suspicion that someone looks undocumented, not sure how you figure that out, you can arrest them. And interestingly, a lot of them are also expanding the use of E-Verify, which I'll talk about in a minute. And I think you'll see more of that in the wake of the Supreme Court decision. And Georgia sadly took it a step further in its bill and would require school districts to report how many kids in the schools are undocumented. And that feels like that's just kind of nipping at the heels of Plyler v. Doe, which I hope we can talk a little bit about in this panel. Anyway, so it's definitely unsettled and some scary times ahead at the state level, but I don't think it's all bad news. And so I think that's something to keep in mind. So at the federal level, what's going on, as I mentioned, Congressman Lamar Smith, as we fully expected he would, introduced a mandatory E-Verify bill. This would require all employers over time for new hires to check the legal status of people when they hire them, which seems perfectly reasonable. There's enormous problems, though, with the database. It's very expensive for small businesses, so I think you're going to have a lot of economic arguments being raised. This is also going to apply to everybody, so all Americans are now going to be asking the government for permission to work, and there'll be probably about 700,000 to 800,000 Americans who are eligible to work who will lose their jobs because of database problems. So this is far from the silver bullet that many conservatives like to point to. E-Verify is highly problematic. There's been an interesting reaction by Congressman Lou Barletta, who you may remember was the mayor of Hazleton and the godfather of one of the very first and fiercest anti-immigrant bills, which hasn't gone very far. And he sent a Dear Colleague letter to all the House members saying, this bill by Lamar Smith is terrible because it limits states' rights. And there's also a similar negative response to Lamar Smith's bill by Chris Kobach, who is the founder and the author of most of these state initiatives, saying, wait a minute, this is an amnesty and this limits states' rights. So it's kind of fun to see the civil war on the conservative side as Lamar Smith is being attacked by both sides. Another area where the federal and state rules around immigration really frankly collide has to do with Secure Communities, which is a program that many of you have probably heard about, where it sounds so reasonable that police can just check the immigration status of people who they book. But what we have seen is that there's been a tremendous rise in people who are being arrested for minor traffic infractions. This was supposed to be aimed at going after serious criminals. We're finding a lot of people, obviously, who are getting picked up who are not serious criminals. It's causing enormous disruption in communities, high level of fear in the communities where people are simply afraid to come forward and have any contact with the police. It's come under such criticisms that states like New York, states like Illinois, states like Massachusetts, where they've had a long history with immigrant populations, know that it's bad. It's making all communities unsafe. And they've said no, and they want to opt out. So you've got this fierce battle going on where DHS is pushing them and saying, no, you can't opt out, you have to do this. The program is on steroids and has been rapidly expanded in the last few years. And DHS, as I said today, is making what unfortunately appears to be some very modest and minor adjustments to the program that we don't think is actually going to do much to stop the great harm that it's causing. So those are just some of the touchstones of how both the federal government's failure to act and how the state is really struggling with how to act are landing, frankly, in the laps of communities, right? They're landing in the laps of people who, some are new to this country, some have been here for generations. But at the end of the day, as I always say, it's not like all the undocumented people live in one apartment building. I mean, you can just say, these laws are just going to apply to you. And I think it's, again, the failure of the federal government to act and to solve the problem that's really causing quite a bit of harm. So I'll stop there, and we'll go from there.
Thanks, Angie. Tom, I'd like to turn to you next because you're you and your organization are very deeply involved in litigation around these issues, and it would be useful to know what the important court battles going on and coming up are.
Well, I think it's a very complicated landscape, and it's going to get even more complicated as we move forward. And you've, first of all, got the SB 1070 case moving forward, as you indicated, with a Ninth Circuit affirmance of the preliminary injunction, and how quickly that is resolved at the district court level will then determine how and whether it will be considered by the Supreme Court or not. And it's out first as far as these statewide cases go. But of course, then you've got the dirty half dozen plus one or so who are in the process of enacting their own replications of 1070. So you got Utah, Indiana, Georgia, Alabama, probably South Carolina, maybe Texas in their special session. And there will inevitably be litigation filed. So you're going to have immediately multiple circuits that are considering the same or similar set of issues. And that's going to complicate the landscape immediately. You have, in addition to that, the fact that, well, the other side, the restrictionists, seem to basically replicate what each of them does. They don't come up with new approaches. They follow what other people have done. They mix and match. So basically you have Chris Kobach's do-it-yourself Frankenstein legislation kit, and people decide, states decide which body parts they want to tack onto their Frankenstein of state immigration regulation. So you get pieces about employment, you get pieces about day laborers' rights, you get the law enforcement piece, you get now the schools piece, you get the benefits piece that goes back decades, and they mix and match. So that means that there are already going to be multiple claims. The lead claim is almost inevitably going to be supremacy and preemption. But there are also going to be 14th Amendment related claims, there are going to be First Amendment claims, there are going to be due process claims, and they're all going to be mixed and matched in litigation based on how Frankenstein was particularly put together in the state legislature that's involved. That's immediately going to mean that various claims and various issues related to particular programs go at different paces throughout the country. The other complicating factor that I would identify is states are not alone. You've still got the local cases. As you've indicated in your introduction, Whiting has led to a reopening of Hazleton. Now that reopening ought to be limited to the employment provisions, but who knows? Who knows how that order from the Supreme Court is going to be interpreted in the district court and in the Court of Appeals. So Hazleton is going to be revived. There are going to be other local challenges because frankly, there are local legislators who, if state legislators can do it, they're going to try to do it. So you've got across the country attempts to address these various issues even at the local level. That in turn is going to lead to challenges. It's inevitably going to lead to challenges because of what I cited before, the pattern of if you don't stop them the first time they do it, it gets replicated by others because they copy each other. So that's going to complicate the situation as well. And finally, the other complicating factor that we haven't really taken into account yet is there is going to be a federal response. I think that what Angie has pointed out about secure communities is the beginning of that federal response. You had the federal government going in and suing Arizona, having declined so far to sue any of the dirty half dozen as they add their legislation to the roster of state-related immigration regulations. So they've declined to do that, but at the same time they are responding to what Arizona did. And this is a disturbing pattern in my view because it happened in the 90s when Proposition 187 passed in California. It begat Title IV of the Welfare Reform Act that restricted in the extreme the rights of immigrants to obtain public services. So in some ways, the folks who are supposed to be defending against the immigration restrictionists, they end up responding and changing policies at the federal level, whether legislatively, the Smith legislation, for example, goes through, but also today more and more through administrative action. So to concentrate on that a little bit, what the federal government does with secure communities, a program that to date really has been a stealth program, today they're going to start to talk about it more and defend it more, but you should have a sense of what the announcement that's going to go on while this panel is going on is by the mere fact that, of course, they're making this announcement at 3 o'clock on a Friday afternoon. Okay. You don't make an announcement that you're proud of at 3 o'clock on a Friday afternoon. Okay? So what it's going to be is lipstick on a pig. But the problem is that this is a vicious, snarling, and rabid pig, secure communities. It disrupts communities. It deports people who ought not be deported. It is being implemented in a stealth fashion to date. And what they try to do today is not going to change the impact on the street of what Secure Communities does. That rabid pig is still going to be running roughshod across the entire country. But the federal government stance is going to change, and they're going to assert that this is their response to legislative action like happened in Arizona and in the dirty half dozen, and that they are also now going to become aggressors against those states that are attempting to enact more progressive responses to immigration-related concerns, including some of the responses that are being considered in various state legislatures, specifically to secure communities. So the federal government is going to start to change its stance. That's going to change the atmospherics. That's certainly going to change what it says in court in Arizona, where it is a party, and possibly in other suits where it chooses to weigh in either as an intervener or an amicus, or if it ever does decide to file a lawsuit against either progressive state or local legislation or against one of the successors to Arizona. So we're going to end up with a very complicated legal landscape. And how that ends up, how it gets to the Supreme Court, maybe it never gets to the Supreme Court. Maybe the federal government's response is viewed as, in practical terms, mooting the issues. Not in legal terms, but in practical terms, mooting, and the issue becomes of less interest and concern to the Supreme Court. Maybe. But it's a very complicated landscape, and it's going to get even more complicated in ensuing months and years. And that's where all of these issues will be acted out in the courts.
Thanks. Dee, a lot of commentators and people who write columns for the newspapers and go on Sunday morning chat shows said Utah's immigration law was the progressive response, that this is moderate, we approve of this. But your organization, SEIU, has joined in a lawsuit against that law as well. Could you talk a little bit about this idea that Utah offers an alternative?
Sure, and thank you. I want to just address the interest that the labor community has in these really important issues of immigration. SEIU has been involved in a number of litigations and has supported legal work on a number of issues around the country, because it's hard to imagine anything that has more impact on labor than a national crisis in immigration. And SEIU, you know, we're a very large organization with an extremely diverse membership. Anywhere between a third to a quarter of our members are members of ethnic and linguistic minority communities who are directly impacted by these kinds of Frankenstein state initiatives. And so obviously we have an interest not only in servicing those members and in providing protection for those members, but it's also a reality in the labor community that you can't protect, the truth being, as Angie mentioned, that people work and live right alongside each other. You can't protect the standards and the working conditions of only documented and U.S. citizen workers. You really have to protect the rights of all workers, including those who are undocumented. Not only is it the right thing to do, but it's the necessary thing to do. So the Utah law, the particular form of Frankenstein that we have in Utah is different. There are some different pieces and parts that were mixed in. And in the most superficial sense, on a level of messaging, I understand the view that it's a more progressive legal approach. And I think that's, if only because it tries to grapple with issues of future flow and the current undocumented population, which, as far as I know, none of the other state approaches really do. And so in its recognition that you can't solve the problems of the broken immigration system in this country without dealing with the current undocumented population and figuring out a rational way of moderating the future flow of workers into this country, it's progressive in that limited sense. The reality of the Utah law, however, is not at all progressive, and it's very harmful indeed for workers as well as others in the state. And I would say that you know, the Utah law is different in that it's a bundle of it's actually a bundle of laws. It has the Frankenstein, the leg from Arizona, which I think almost all of these state initiatives are borrowing now. And those are the sort of show me your papers provisions from Arizona. And then it has a sort of odd set of laws that create a state guest worker program and that create state visa sponsorship programs. They're a little bit perplexing in not only for constitutional and supremacy reasons, but just on
How would it work?
basic logic and practical considerations. But that is the difference between the two sort of basic approaches. And I think apart from the significant constitutional problems with creating a state guest worker program and visa sponsorship program, there are some real reasons to be opposed to that kind of program from the perspective of labor, and they're pretty harmful to workers. Guest worker programs don't enjoy a particularly good history and record in this country in terms of worker protections and in terms of preserving wage rates and standards and working conditions, even when they're implemented at a federal level. And the labor movement has been grappling with a lot of these issues for a long time, and across the movement, the AFL, CIO, and Change to Win unions have arrived at some principles and a framework for what we believe has to be addressed in order to fix our very, very broken immigration system. And one of the cornerstones is that any new approach must involve dealing with the current population of undocumented workers and finding a way to adjust status so that those workers can be lawfully present and lawfully a part of the workforce. And without that element, a guest worker program leads to significant exploitation of workers and simply cannot, as a practical matter, solve the problem of immigration in this country. The sense in which the Utah law is very much like Arizona is the sense in which it requires employers with over 15 employees to utilize the E-Verify system. I think there are lots of well-documented concerns around the use of E-Verify and the accuracy of the database, and a lot of very important debate around the efficacy of that program. Even leaving that aside, if E-Verify were to work perfectly, when you use it in the absence of some mechanism to adjust the legal status of the bulk of your undocumented workforce, it has the net effect of driving workers into the informal cash economy. And it drives them off of tax rolls, and it drives them out of utilizing worker protections that are so important not only for undocumented workers, but for all workers. And I think that's a really significant problem, not only on a federal level. I mean, this is something that's only exacerbated when states implement these models, mandating participation in E-Verify. Right now, the United States has one of the lowest rates, one of the smallest informal economies. Somewhere around 9% of our economy is off the books or informal. But when you have these two competing business models, and you have these high road employers who employ workers, pay their taxes, pay into workers' comp, follow to some degree at least the legal requirements for health and safety for their workers. And then you have workers who are fly-by-night and who utilize undocumented workers off the books in a way that allows for serious exploitation of those workers and in a way that drives the working standards down. And really what we have with E-Verify is that we're changing the way the economy looks, and we're changing the way that work is structured, and it's to very negative effect. And so that in a nutshell is why SEIU is so interested in this issue and why the labor movement has to be and is very invested in finding a comprehensive federal solution to these problems.
That's great, thank you. Neil, as a scholar of federal preemption generally, which obviously takes in a lot of areas, tell us a little bit about the underlying principles that are at stake here in whether a given local or state measure is preempted by federal law.
Okay. The basic principle that's at stake is the supremacy clause. So that's where all preemption law flows from. The Constitution provides that the Constitution and laws made in pursuance thereof are the supreme law of the land, which means that they preempt state laws. Okay, federal law preempts state law. I'm a little sort of self-conscious about talking about this with Michael right here, who's written all the books on it, but you asked me, so I'll go ahead.
It's my fault. Yeah, I'll take it.
There are several different versions of preemption. First, there's express preemption. If federal law expressly states that it means to preempt state law, then it does. If federal law doesn't expressly state its intention to preempt state law, it may nevertheless still preempt state law if the federal law occupies the field, right? Means to be the exclusive legislation on the subject, then states are not allowed to legislate on the subject. Lastly, federal law can preempt state law by conflicting with state law, and there are two ways that federal law is said to conflict with state law. One is if it is impossible to comply with both. So if, for example, a federal law says that all trucks must have contoured mud flaps, and a state law says that trucks have to have straight mud flaps or no mud flaps at all, it's not possible to comply with both, federal law wins. The other way is if state law is said to be an obstacle to the accomplishment of federal purpose or policy. So those are the basic types of preemption. There is a presumption that federal law does not preempt state law unless it expressly says so, if the state law at issue operates in a traditional area of state power and state regulation. So for purposes of this discussion, that would be employment law. Okay, states have traditionally regulated the employment relationship, and so there's a presumption that state laws operating in that area are not preempted. However, state laws that are not regulations of the employment relationship, but that in fact are regulations of immigration, do not enjoy the presumption against preemption. And in the Ninth Circuit case on the Arizona law, that preemption, or that presumption actually worked importantly to help the Ninth Circuit uphold the injunction and prevent the enforcement of SB 1070, because for the most part, the Ninth Circuit saw SB 1070 as operating not in areas of traditional state concern, but rather as being regulations of immigration. The one exception to that, the Ninth Circuit nevertheless found that that the federal law preempted the state law because the federal law meant to preempt state law. So that's sort of the Hornbook version of preemption.
Thanks. Mike, as has been indicated, you kind of cover the waterfront in this area, all the way from federalism and preemption to questions of citizenship, and I think we'd be grateful for your comments on anything you've heard so far, or anything else in regard to this issue.
Look, I feel, thank you to all of you, and thanks to the ACS for having me here. I too feel a little self-conscious about this because I know next to nothing about immigration law. As you might have guessed by now, my name sounds funny, I sound funny, I am in fact an immigrant, I am here on a green card, which I do carry around, but my response to that is not, hey, this is really interesting, I want to know more about it. It's stay away as far as you can from the government. Having said that, the way I got into the subject and what interests me and why I'm grateful to be here is in fact the preemption aspect of this. Neil has summarized sort of the Hornbook version very, very nicely. I'll add to that, to his observations, this. The orthodox progressive position on preemption is we are against preemption. We are against preemption. Whether you talk about banking regulation or pharmaceutical regulation or anything else, we are against preemption. It is always good to have state regulators on top of federal regulators. This is what Erwin Chemerinsky calls empowerment federalism, what other observers in that same vein have called polyphony. I trust that nobody here believes that about immigration law. More enforcement is always better enforcement. We are always against preemption? No. These cases, the immigration cases, to my mind, sort of demonstrates the danger of having, you know, hundreds of self-appointed enforcers all over the place. The first instinct is always to say, well, immigration is special. There's this foreign affairs overhang, and it's also an exclusive power, which, to my mind, all other powers except the tax power are also. But that's the basic impulse. That is the strategy the Justice Department has been assiduously pursuing in its briefs in these cases. I believe that is wrong. And I believe that it is possible to have sort of a set of presumptions, set of principles with which you can approach preemption cases in general. I believe that Whiting was wrongly decided. I believe that that Justice Breyer was right in that case. I believe that most parts, certainly, of SB 1070 are unconstitutional under the Supremacy Clause and existing federal law. But I believe that for reasons that would make none of you particularly comfortable, because I would apply the very same principles also to other areas of regulation, from global warming regulation to banking regulation, where those same principles would have what you would call conservative or libertarian results. So be it. I don't care about the results one way or the other. I mean, if they vary across board. I believe, however, that immigration law, with the possible exception of labor law, is one of the very, very few areas where you can still sort of approach progressives and say, look, the general preemption principle that conservatives and the Chamber of Commerce stand for, in fact, have some merit, and those merits will be obvious to you if only you look at the consequences and how this plays out in, quote unquote, your arena. And I'd be happy to sort of pursue what those principles should look like if somebody has the nerve to ask me.
Thanks. Now, I'm going to throw some questions out, and you guys bat them around.
Do you mind if I?
You want to say something?
Yeah.
Sure.
I just wanted to fill out some of this recent discussion, because certainly from the advocate's perspective, and I say this from having dealt with these issues with Proposition 187 now, 17 years ago. Immigration is viewed as an exception, and that exception in part comes out of the last time before Whiting that the U.S. Supreme Court directly addressed an issue of preemption in the immigration field in De Cañas versus Bica, which is an old case, 40 years old at this point. Before IRCA, and it dealt with employment, obviously before the 1990 Immigration Act, obviously before the 1996 set of acts that the Congress enacted. But in De Cañas, there is an assertion that there is another kind of preemption in the immigration context, which is what I would call constitutional preemption. Specifically in that decision, the court says, even if Congress didn't enact anything related to immigration, even if there was no INA, even if there was no title of the US Code dealing with immigration, there would be some modicum of immigration regulation, and it was described, I believe, as the determination of who's allowed to be and stay and the conditions under which they're allowed to be here, that would be off limits for states. So it's not like field preemption in the sense that, according to the Supreme Court in that case, you don't actually have to have a congressional enactment, that there is something that is essential to nationhood that you can't have 50 states regulating when it comes to immigration. So on top of this, you'll see in all of these cases an assertion that some of these state laws in particular go into that area, that it doesn't matter what the Congress has done. If even the Congress had done nothing, they would still be preempted because they strike at that core of immigration regulation that is so essential to nationhood. Even if Congress did nothing, states can't invade that area. And I think it's important to know that in respect to this. I don't know whether the current Supreme Court, if it got to revisit it, would say there is still such a thing as constitutional preemption in immigration, but it's what's there on the last decision prior to Whiting that specifically dealt with preemption, supremacy in this particular area.
Can I
Yeah,
just,
Mike, take it.
so just add one observation to that? That's right, and that makes it like the Dormant Commerce Clause, right? Which also says that even if Congress hasn't said a peep, there are certain things that states must not do because they are in conflict with commerce among the states, and it's like that. What I'm worried about here is, I mean, I gave the impression that, I'm arguing with you progressives and I really want to get into your face. No, who I'm arguing with, because I still have a chance to persuade them, are Antonin Scalia and Clarence Thomas. Both justices no longer believe in the Dormant Commerce Clause. Both of them have been very, very critical of implied preemption. That explains their votes in Whiting, not some sort of anti-immigrant sentiment or anything like that. And if this thing, I mean, if this presumption of there's a core of immigration that is even that is preemptive, even if Congress has said nothing, if you present that theory to them, I would say they would say, I should think they would say, go away, because that's just like federal common law and we can't have it. And I'm on the other side of that argument.
Neil or anybody else want to tackle that before we go on?
Right, I guess one other observation, I completely agree with Michael that this is like the Dormant Commerce Clause, is to then also recall that the Dormant Commerce Clause is a default rule, right? Congress can change it, and just as in the Dormant Commerce area, Congress can authorize the states to regulate, and so that's something else to be worried about, I think. But that is something that would be constitutionally permissible.
Anybody else? Before we go on to another question, I do want to note one of my students is in the room, and I told you you needed to learn the Dormant Commerce Clause. Thanks for the validation, gang. I really appreciate it. I want to throw out something we haven't covered in the local legislation area, and I know is of great concern to a number of you, and that is the attempts, various attempts by states to inject themselves into the issue of birthright citizenship for children of the undocumented. And as a constitutional lawyer, this is very present to me, but I'm curious what you're seeing on the ground and what is going to come out of this in terms of policy and legal challenges. I don't know if anybody wants to tackle that first. Nancy, you want?
I think it's had the effect of scaring the Latino community, because the questions that we get the most often are, oh my God, are they really going to do this? I don't think it actually presents a threat that it would pass constitutional muster. So I'm not worried about that from that perspective. A lot of people have asked me why my institution is spending so much time pushing back on challenges to birthright citizenship. And I think it's because it is so core to who we are as a nation that you can't let the suggestion that we're going to create a second class of people who are born here and them not be citizens go unchallenged. I was given the opportunity to go to Berlin a few weeks ago and speak to a group of really smart people from the government and from the press and from think tanks about birthright citizenship. And it was extraordinary, not because of language barriers, but because of just cultural barriers, how they didn't get why we were so concerned about it. It is so fundamental to this country's character that if you're born here, you belong. It's not a country club. And that is what I think is, frankly, the genius of this nation, that we integrate from the moment we're born. And if we take that away, I think the consequences are something that would frankly undermine our greatness and leave us quite crippled.
You know, I think it's been now 5 months since Chris Kobach rolled out what I would call Frankenstein legislation kit number 2 relating to citizenship by birth, and it had 2 major parts. It had this interstate compact idea and this idea of reviving a notion of independent state citizenship from national, but basically admitting in that piece of it, it had no practical effect whatsoever. And this version of Frankenstein kit 2.0 is like some version of Windows that nobody's buying it. I mean, they don't like it. It's got no traction. It's not gone anywhere, and I think that that's encouraging. It's in part because I think Angie's right. If they tried to do this, they'd be in court and they'd lose. But I also think it's because of what Angie also talked about, which is this is such a core principle that they're not going to get traction on it particularly. There's a part of me that thinks it was a diversionary tactic. I think it's backfiring on them because I think it is galvanizing levels of support that otherwise weren't so strongly out there before. So even as a diversionary tactic, I don't think that their assault on citizenship by birth is working. I'm a little more concerned about what they went and hid under the floorboards when they decided to come out with this unified, what is it, state legislators for legal immigration approach to the issue. And what they went and hid under the floorboards were proposals before that would have, through state legislation, made it virtually impossible to prove your citizenship if you were the child of undocumented immigrants. The proposals that were being under discussion until they did this involved things like putting high fees on obtaining a birth certificate if the mother of the child was undocumented, and putting a condition on obtaining the birth certificate that you would then, as the mother, be reported to ICE. And those kinds of things are of more concern to me. I think they're still constitutionally vulnerable from a litigation perspective, but I think they're extraordinarily dangerous because they basically mean they're not denying citizenship, but if you don't have the ability to prove your citizenship, it's tantamount to not having it. I mean, you do create a class of stateless people without actually changing the Constitution, which is what they're trying to do with the compact and the state legislation as well. But in some ways, that concerned me even more. I'm happy that they decided to go hide that under the floorboards and not talk about it or pursue it in any way at this point.
Yeah, Garrett, I'm sorry if I'm being didactic here, but I think it's an occupational hazard for us professors. And I do think it's a really important point to make is why some of the history that amplifies why this is so important, birthright citizenship. It was the law of the land at the beginning of the Republic, right? It was the common law of the land that Chief Justice Taney, in the decision that occupies pole position for worst Supreme Court decision ever, Dred Scott, repudiated, right? Dred Scott said descendants of Africans cannot be citizens, cannot have rights that white people are bound to respect. It was that decision that was rejected by the constitutional experts on Missionary Ridge, as Professor Charles Black used to put it. And then after the Civil War, in the text of the 14th Amendment, that's precisely the view that the 14th Amendment was designed to reject. Not because merely it's an abstract principle to which we are committed, but rather it's a principle to which we were not fully committed before the Civil War. And in reconstituting ourselves, reconstructing ourselves after the Civil War, it was a fundamental principle that we would not go back to that way of viewing people. So we have tried that approach before, and the result of that, or the embodiment of that view of the world, is Dred Scott. It's that ugly, and it ought to be rejected in those terms, and we should never forget where that comes from.
Mike?
I'm no expert on this, just add to it. Not all countries in the world, of course, have our regulations of birthright citizenship. My objection to messing with it is that if you abandon it, you end up like my home country, Germany, right? With generations of people who have no way, who are permanent strangers in the country where they live. That has nothing to do with Dred Scott. Germany, God knows, has its own problems in these regards, you know. But it is a very, to my mind, a very sort of potent policy consideration that would make me, makes me personally recoil at some of the stuff that's going on in these circles.
Anybody else? Let me ask you about something that several of you have alluded to, and that is obviously one of the reasons this is happening at the state level is that the federal government has not been able to bring any sort of comprehensive reform to bear, and now we have a situation where the federal government, the Congress is what it is. Let me just put it that way. What
Nicely
can
said.
we expect to be coming down the road from the federal level in response to all of this situation?
I'll start. I think a lot of shouting, but not a lot of action or solutions. As I said, in the House, the Judiciary Committee will be taking up the E-Verify bill, and they'll be considering it in committee or marking it up as early as next week. I think it'll be a pretty predictable outcome to that vote, with Republicans supporting it and Democrats not supporting it. I think it will pass on the House floor, and it's the intention of the Judiciary Committee chairman to do that, you know, perhaps as soon as in July, before the August recess, or September. But, you know, it's hard to get a bill passed in both chambers. And the Senate Democrats are going to view this very differently. The Senate is frankly in Democrats' control by a narrow margin, but the election results from last year, in no small part, ended up the way they did because of the strong turnout by the Latino community, particularly in Colorado and in Nevada and in California. That's something that I think is etched in the minds of some key Senate Democrats. But there is a question about what will the Senate do. Will it just avoid this issue between now and the election? That's going to be hard to do. It's a long time until the election. And I think there's going to be some presses and some challenges there. If Republicans, though, try to move it as an amendment, then they're probably going to need 60 votes in order to cut off debate, which means to stop it, we only need 41. I don't think it's the kind of bill that Harry Reid, the majority leader, would just bring up on his own. So it'll probably be incumbent on the Republicans to get a lot of votes, and I'm not sure that they'll be able to. There's also a lot of pressure, not as much on Congress, but frankly on the administration, to offer administrative relief. As people probably know, this administration has been deporting more people than the previous administration. It's coming under a lot of attack because of its aggressive enforcement policies. And there's been a lot of challenges, particularly around the situation of DREAM Act kids, for example, who continue to be removed. And so I think that some of the fireworks, if you will, are going to be on both ends of Pennsylvania Avenue between now and Election Day.
Here's a shot in the dark. Is there any possibility of something good coming from the federal end in the next little while?
No?
I was
I mean, I
afraid
think-
that was going to be the answer. Tom?
I mean, if past is prologue, then the answer is clearly no. I mean, I think the experience for the last 10 years has been that we've been trying to get comprehensive immigration reform. It's supposed to be a grand compromise where you get the good and the bad. And while we've got none of the good over 10 years, we've gotten a lot of the bad. And sometimes that's done administratively, sometimes that's done selectively, legislatively, but that's where we end up. And unfortunately, that's where I think we're going to see more of. On the administrative side, Secure Communities is Exhibit A in improving what I just described, and I think the administration is going to be even more aggressive, as I said earlier, about using that program. I think they're going to, as they're going to announce right now, they're going to create a commission. Who knows what that commission is going to say, and whether it will be any sort of meaningful pulling back on what Secure Communities does. At the same time, the administration is, at least so far, not given any indication that it's going to provide any of the relief that Angie talked about to DREAM Act kids or when anyone else using the administrative authority that they have. So it's not particularly encouraging. The only encouraging aspect is also what Angie mentioned, which is to the extent people want to pay attention to the 2010 November election, and particularly what happened on the West in the country with participation of Latinos, and then wants to look at the census data and figure out that, well, that's going to expand in the future. And the latest polls tell us that the #1 issue of concern to the Latino community is immigration, 51%. And that's got to start to penetrate both parties, and maybe that's the only hope for getting something on the progressive side in the immediate future.
Neil, you mentioned something to me before the panel that I found interesting, and that is that floating around in these cases is not simply federalism and preemption as an issue, but separation of powers. And I'm not sure, people fully understand the implications of that, although I think it's floating around in the United States versus Arizona opinion. But do you want to say something about that?
Sure. I guess the first thing I want to, well, maybe the problem is that I do separation of powers. That's my focus, my concentration, and this could be just an instance of when the only tool you have is a hammer, every problem is a nail. But it occurs to me that there might be a real separation of powers problem with some of the Arizona type laws. And the problem is based on a view of separation of powers that I don't necessarily subscribe to, but people like Justice Scalia and Thomas do. And that view is that the executive power is vested in the president, that the president has to have control over all enforcement of federal law, that it is unconstitutional to deprive the president of control over the execution of federal law. If that's right, and in fact, Justice Scalia said exactly that in the Prince case. If that's right, the Prince case was the Brady Act case, which was mostly a federalism case, that you couldn't require Sheriff Prince, if he wasn't willing to do background checks before a gun could be purchased. But in the midst of that opinion, Justice Scalia dropped in a paragraph in which he said it also violates separation of powers because by giving that authority to Sheriff Prince, who is not subject to the president's supervision and control, right? The president's authority as chief executive is undermined, right? Impermissibly undermined in violation of the separation of powers. If that's right, then giving authority to state officers to enforce federal immigration law, other than under the 287G procedure, which does authorize state officers to enforce federal immigration law under the supervision and control of the Attorney General, through whom the president can then exercise supervision and control. But when states go out on their own outside that 287G process and seek to enforce federal law, the president no longer has the executive power. And there are a bunch of ways in which the president might want to exercise the executive power that would be at odds with the way state officers would want to. So, for example, the president might be quite risk averse about instituting any operation that might run the risk of involving racial profiling, whereas the sheriff of Pima County, just to pull one out of the air, might not be quite as risk averse as the president. The president might also be quite reticent about doing anything that has the appearance of involving racial profiling because of concern about the credibility of law enforcement across the board in ways that, again, the sheriff of Pima County might not feel the same way about. That's the president's job to make that decision with respect to federal law enforcement, not a local sheriff's. And then there are the diplomatic concerns as well, right? That would be the hard constitutional claim. That claim can also be raised in other ways that would be relevant to the litigation. One would be to invoke an old favorite from the Bush administration, the avoidance canon. That is, don't interpret federal law to authorize states to enforce federal law outside of 287G, because to do so would raise this serious constitutional problem. To avoid the constitutional problem, interpret state independent law enforcement efforts as being preempted. The third way of that sort of having an impact on the litigation is just to amplify the preemption arguments that are already being made. That is, there are important federal interests that state enforcement is an obstacle to, even though the states have the same policy or the same goal as the federal government. That is the one on paper that undocumented aliens can't work or can't be here or whatever it is. The state says, well, federal policy, state policy, they're the same. But there's a lot involved in enforcement of federal law that involves policy decisions where those enforcement policies could be at odds, and so interpret the federal law as supreme and preempting the state law.
Mike, did
Right,
you
and
want-
one more sort of variation on that same theme is to say, look, those kinds of arguments are a reason for reading the deputization procedures as exclusive. If we want to have cooperative mechanisms between the feds and the states, that's the way to do it, precisely on account of those kinds of considerations. There's another separation of powers argument that I've seen sort of made. I'm not sure I believe it or how serious it is, but I'll mention it nonetheless because it's out there. The exclusive authority here, if it is exclusive, is that of Congress, not the administration or some bureaucratic agency someplace. With respect to discretionary law enforcement, discretionary regulation of immigration, yes, it is entirely possible that decisions not to enforce, decisions not to regulate have preemptive effect. However, there are suggestions in the case law, not from the immigration field so much, but from other areas, that if you want to do that, if you want to attribute affirmative preemptive power to a decision not to intervene, it has to rise to a certain level of formality, if not necessarily full-blown notice and comment rulemaking, at least something close to it. It's not enough to just, the concurrent or the present litigation position or some affidavit that these are our priorities might not be enough. Again, I don't know how much that is worth, but it's out there.
Unless anybody else wants to tackle that, I think we should move now into our question and answer period. And I think there's a microphone situation, so whoever asked, the things we're asked you to ask you are, would you please ask a question? Could it be relatively short and to the point? And would you wait for the microphone? So,
Garrett, sorry, I did want to say just one thing quickly, which is, I think that as the federal government gets more and more aggressive, if it does, about enforcement, that some of these questions may also arise vis-a-vis what the federal government is doing, both separation of powers concerns and, of course, the flip side of preemption being the 10th Amendment. Let me just footnote that we brought a 10th Amendment case in response to a portion of Title IV of the Welfare Reform Act, because in that situation, the Congress enacted and President Clinton signed a provision that basically said, we're setting up a presumption that even for state-provided benefits, wholly paid for by state funds, we are setting up a presumption that undocumented immigrants are not eligible. However, states can overcome that presumption, but they can only do so by specifying in their legislation that they are making the decision to have undocumented immigrants eligible for this service, and included a provision that said, and you have to pass new legislation after the Welfare Reform Act went into effect. And our argument was, of course, we had to defend supremacy with respect to immigration regulation, but our argument was states get to decide how they enact legislation. And it's conceivable that a state could decide that every one of its laws sunsets after 5 years, or sunsets every year, or sunsets after 10 years. But if a state decides that its legislation does not sunset unless it specifically says that, then Congress can't override that and say to a state, you have to reenact a law that you already had on the books because we've passed the Welfare Reform Act. Now, the case never got very far because we lost, I think incorrectly, but we lost on an issue of severability in the district court, and the case was mooted. It involved a California law that for a long period of time had provided prenatal care benefits to undocumented women. It was mooted because there was a change in governor, and then you could get reenacted what existed before the Welfare Reform Act. And incidentally, we all knew that that Welfare Reform Act provision and those specific requirements that I went over was specifically targeted at California and specifically targeted at the prenatal care benefits that at the time a democratically controlled legislature still supported and a Republican governor, Pete Wilson, opposed.
So we'll start with you, and then we had a question over here. So wait for the microphone, please.
So there was a lot of discussion about, I guess, the cutting edge of legislative efforts to cut back, but the courts are being pretty creative too, and being creative in ways that I could not have anticipated. In the same way that if you had asked me in 2008 if there was an inactivity exemption to the Commerce Clause, I couldn't have anticipated that even being an argument. So like the most recent example is the Fifth Circuit just said that because the Second and the Fourth Amendment refer to the right of the people, if you're in this country illegally, you're not part of the people, and therefore, you don't have any rights. So I guess my question is, how else are they being creative, in ways that may not necessarily be in the news. It may not be something who someone who is familiar with precedent would come up with, but apparently judges who want to undermine immigration rates can.
Hey, who wants to tackle that one?
I'll tackle it by saying I don't know. But I think the Fifth Circuit blindsided us. Absolutely blindsided us. And frankly, the Fifth Circuit has a history of being creative in some of the ways that you aptly described in this particular circumstance. We're going to look very carefully, of course, at what the Fifth Circuit decided. Not a case that I ordinarily would have an organization like MALDEF involved in. I don't frankly believe that there is or ought to be an individual right under the Second Amendment, so I'm obviously quite conflicted about what to do in a case like this. But it was a blindside, and I think there will be others like that. And you've got to keep your eye on where these issues come up in unexpected ways and where judges who may have an interest in engaging in the kind of undermining that you've described may find the opportunity to do that. And I think it's what complicates the landscape even more and makes the job all the more difficult.
If no one else, then
Well,
it's-
one other is the people obviously does include corporations, right? The Citizens United, that was pretty creative.
not undocumented foreign.
Right.
We have this lady.
Yeah, the more I think about my question, the dumber I think it is. So if you think it's a dumb question, then please feel free to say so. You were talking about the concern of unions and about these immigration cases, policies. Is there any connection between feelings, anti-union feelings and anti-immigration feelings? Do they feed into each other in some way, or is it just coincidental that the same people are?
Well, traditionally and historically, unions haven't always been natural allies with the immigrant population. So I think the position that labor has come to now is far closer, obviously, and is sort of really grappling in a meaningful way with how these issues interact and the reality that immigrants are a significant part of all of our communities and all of our workplaces, and in some sectors very much more than others. So I don't know. Certainly it's also true that unions are on the receiving end of a lot of hostility in the United States right now, and that there is a real effort underway to stop the activity of unions and to try to hinder advocacy on the part of the middle class and the working class and union members and non-union members. And I suppose that might be part of a larger context, but I'm not quite sure how they connect. I don't think it's, for the record, I don't think it's a dumb question. I may just not have the right answer.
This gentleman here.
I had a question. I think Tom, Neil, and Mike probably best be able to answer it. I'm from the Commonwealth of Pennsylvania, and I follow the Hazleton, and I was just curious to know, especially given your expertise, Neil, whether you think that if they address the landlord-tenant issues in that case, that will be preempted or not. It's just speculation, but I just wanted to get your input on what you think the court's going to do in that case.
What, you mean on the remand?
Yeah.
Yeah, I mean, I think, it's a one-line, one-sentence remand. I think they ought to confine their revisiting to the employment provision. I think that Whiting is basically an express preemption case. And in the landlord-tenant context, a express preemption case with a savings clause that ends up being the linchpin of the decision, I don't think there's an equivalent argument on express preemption and a savings clause with respect to landlord-tenant. That doesn't mean that a creative court might not decide to use this as an invitation to go look at other provisions.
Right, and I think that creative court then might look not at the provisions that you've cited, but rather at the E-Verify provisions and say, well, landlord-tenant law is a traditional area of state concern and state regulation. Therefore, we're going to presume against preemption. And although the E-Verify provisions at issue in Whiting included a direction that the federal government was not to mandate the use of E-Verify. That didn't mean states couldn't do it, right? So if we look at Whiting's tea leaves, maybe that indicates that landlord-tenant law is another area like employment law where the court is going to be reluctant to find preemption unless it expressly says so. Again, I don't mean to suggest that would be correct, but if you want something to worry about, there it is.
No, that's it. My sense of it is this, and this does go to the hey creativity angle. My sense of it, just looking now impressionistically and not at this precise holding, but at the tone of these decisions. There will always be in any area judicial decisions that sort of catch you unawares, right? And that where you say, where did that come from? There are areas in which the Supreme Court wants to be very enterprising. To most of you, Citizens United may be an example of that. My favorite example would be Massachusetts versus EPA, where, you know, I can't make heads or tails of that decision other than there's a global warming exemption to every known principle of American law. That is really a surprise. I really doubt that this context, immigration, will see very many of those decisions, certainly from the highest councils, and the reason is you're playing with fire and they know it. Global warming is, you know, at the end of the day, yeah, maybe the planet is disappearing, but it's, you know, few of us sort of run around on a daily basis and worry about it. Immigration is really different. It's much more visceral. It's much more dangerous politically. And reading over the Whiting opinion, the Chamber of Commerce case, it doesn't say carte blanche, so long as you call it a licensing law. Go to town, right? It's sort of, it has all these passages where, well, it's really kind of sort of consistent with the feds and E-Verify and how about this and how about that. It's a lot of hand-wringing. And the remand order is, you guys figure it out. One restriction at a time, one body part, one limb at a time. That's not very satisfying for anybody, at least not in the abstract. But then, I mean, the alternatives are even more unpalatable, I think.
We have time for one or two more, so let's, how about you there? You in the red dress, yes. No, it needs for the recording.
Oh, okay.
Yeah.
I'm with the Equal Employment Opportunity Commission, and one issue that I've been dealing with is, and I'd like your guidance, is in situations where we're litigating national origin discrimination cases, and our theory is that part of the reason why these individuals were discriminated against is because of their national origin, and also in part because no one expected they'd ever complain. Should we acknowledge in our litigation to the judge, to the jury, the elephant in the room, which is they're being exploited, as Fitzpatrick said, because of their documentation status, and take all the risks that come along with that? Or should we not be distinguishing these undocumented workers from the other individuals who we represent and just brush that issue under the rug?
That seems to come to you, Tom.
Yeah, that's a difficult question, in part because as I was sitting here and thinking about your question, I would have eventually said Hoffman Plastics is the other sort of example of a decision that was creative and not necessarily coming up in the context that you would expect that kind of decision to come up with. And I would be very concerned about raising it. I don't like the swept under the rug characterization very much, but I would be very concerned. And in virtually every case that we bring on behalf of undocumented employers, the other side tries through discovery to prove that the plaintiffs are undocumented, and we try like hell to make sure that they don't get access to that. And I think opening up that Pandora's box would be incredibly dangerous, recognizing that it may take away a little bit of the strength of the motive case behind the kind of litigation that you're talking about. So, tough question.
One more?
Hi, Peter O'Mara. I work with Catholic Charities of Milwaukee Legal Services for Immigrants. I'm going to ask you to get into the administration's head a little bit. A
Please
lot of
don't.
the enforcement prerogatives have been kind of with the pretext that only by securing the borders or getting some sort of control over the situation can we move to a comprehensive immigration reform. Does that seem like still a genuine or realistic policy objective in what the administration has been doing?
Do you want to go down that rabbit hole first?
The president answered a question at his press conference after being in office for 100 days. It was Lori Montenegro of Telemundo who basically said, are you being aggressive on enforcement as a way of, setting the terrain for legislation? And his answer was, I have to show the American people what, it's my duty to enforce the law. I have to show the American people the limits to that, because fundamentally our system is broken and only Congress can solve the problem. And as we know what happened, he was very aggressive on the enforcement piece, and the legislation faltered for a lot of reasons that you all know and we could discuss for a long time, maybe over a beer, but not now. And there are some improvements, right? We don't have the big raids of Postville, Iowa anymore. There is better treatment of people in detention. I mean, they have made some efforts. It is a very big steamship. It's not a sailboat that they're trying to adjust. Course on. That said, there's also been this extraordinarily aggressive push through secure communities that I think just caught wind in a way that they couldn't have anticipated. And it has unleashed, and it didn't start with this administration, I actually think it goes back to Ashcroft, this notion of police being immigration agents. And that's very dangerous for a lot of the reasons that I started this panel with. I think that's toothpaste that's long gone from the tube that we can't put back in so easily or blame just this administration for. I think that, though, where the administration has power, the discretion it has in who it prosecutes and who it doesn't, it's like fundamental. You guys learned that the first day of law school. They seem to be hiding from that. We hope today, as they reissue a memo on prosecutorial discretion, as they indicate that there should be a process for deferred action for young people who would qualify for the DREAM Act in removal proceedings that shouldn't be removed. I mean, we hope that they take those steps in that direction. But there's been more than 2 years of super aggressive enforcement action, and they can't unring that bell.
Oh.
And I would just say, I'll give the sort of cynical response, which is whatever the truth to that earlier in the administration, what is going to dictate what they do now is their re-election campaign. So, that was a rhetorical response, and it may still be the rhetorical response, but what the administration actually does is going to be motivated by what they think the president needs to be reelected. And that's going to be dueling concerns. One is about wanting to look tough on enforcement for some segment of the electorate. How large that segment is, who knows? And the other is he's got to do something that's going to respond to the 51% of Latino voters who think that this is the #1 issue. And they don't think it's the #1 issue because they want to see more enforcement. It rose to becoming the #1 issue because they're concerned about the enforcement with nothing on the progressive side.
Dee, did you want to chime in on that?
I'm not sure I have a lot to add. I mean, I agree that, the issue of enforcement only is obviously a pressing issue, and I'm with everybody else in speculating about whether we can expect anything more than that until after the next election.
Well, on that note, I think, I don't think we've solved these problems. My prediction is that at next year's ACS convention, we will have a panel called Son of Frankenstein. And I hope some of you will be here, and I hope some of these panelists will be here. Please remember, we have the remarks at 5 o'clock in the presidential ballroom. And please join me in thanking this absolutely splendid panel.